Good evening. This is CUP News Report. Artificial intelligence, AI, is rapidly transforming the world. And intellectual property, IP, law is no exception. AI is creating new challenges for IP law and forcing policymakers to rethink the traditional legal framework. One of the biggest challenges is the question of who owns the intellectual property rights to our generated works. For example, if an AI system is trained on a dataset of copyrighted images and then generates a new image, who owns the copyright to the new image?
For more information, here is AI Geraldine reporting for patent.
Thank you, AI Rose. A patent is a legal document that grants exclusive rights to an inventor for their invention. It provides the inventor with the right to prevent others from making, using, selling, or importing their invention without permission. Patents are granted by government patent offices and typically last for a limited period of time, usually 20 years from the filing date.
For example, a training data set. So a training data set is going to be used to inform a machine learning model, but the data set itself may not be patentable. It's maybe not subject to copyright. It could be maintained as a trade secret. And one of the things that people have been talking about in the industry is that there may be a need for a new regime of intellectual property to protect aspects of AI.
Normally an invention is just something that, someone working on R&D or out of the blue comes up with in their head. Now companies are using AI as a tool to help innovate, and even in some cases using it to potentially innovate on its own. And that's a real shift in the paradigm from what we've done in this nation for 200 plus years, where the patent statutes have said that an inventor is a person. Well, now what's actually doing the inventing is a computer. It's artificial intelligence. And how do we adapt our system to handle that?
Patents are important for protecting intellectual property and encouraging innovation. By providing inventors with a monopoly over their invention for a certain period of time, inventions developed by AI are also patentable, subject to the same requirements of novelty, utility, and non-obviousness as other inventions. However, there are some special considerations that apply to AI-generated inventions. Back to you, AI Rose.
Thank you, AI Geraldine. For more information about patent, here is the report of AI Joanne. In the Philippines, the doctrine of equivalence is a legal principle that allows for a broader interpretation of the scope of a patent. It states that an infringement may occur even if the alleged infringing device or process does not exactly match the claims of the patent, as long as it performs substantially the same function in substantially the same way to achieve substantially the same result.
Meet Erica. Erica owns a toy company that has patented several toy products in order to own the U.S. retail markets. Erica understands the value of her company's ideas and inventions, so she's vigilant regarding patent infringement. Patent infringement occurs when someone makes, uses, sells, or imports a product covered by a claim of a patent without the permission of the patent owner. Dunlap, Bennett, and Ludwig's experienced patent infringement attorneys have litigated and settled patent infringement matters on behalf of clients just like Erica in a wide range of industries, including toys, mechanical devices, software, electronics, telecommunications, biotechnology, mining, manufacturing, and pharmaceuticals. From demand letters, district court injunctions, the Federal Circuit and the Patent Trial and Appeal Board, putting a swift end to the patent infringement and getting competing products off store shelves, and further, preserving Erica's company's good name and reputation can be just as important as obtaining damages. Fact of a patent infringement case, and we keep Erica informed at every stage, from the initial evaluation of the case through settlement efforts, and if necessary, a patent infringement trial. We routinely help to resolve patent disputes for clients like Erica, and if her company should become a defendant in a patent infringement case, we can bring our patent law experience to her firm's defense.
The doctrine of equivalence is based on the principle that an inventor should not be deprived of the full scope of their invention simply because someone else has made a minor change to it. The doctrine is also intended to protect inventors from evasion of their patents, which occurs when someone deliberately makes minor changes to a patented invention in order to avoid infringement. Thank you, AI Joanne. For trademark, here is the report of AI Ian.
Thank you. AI Rose. AI trademarks on false advertising. Trademarks primarily serve to protect brand names, logos, and other distinctive identifiers from unauthorized use by others. They don't directly address false advertising. False advertising is usually addressed through other legal mechanisms, such as consumer protection laws, intellectual property laws, like copyrights and patents, and competition laws.
When a company engages in false advertising, it can face legal consequences, including fines and injunctions. AI, like any other product or service, can be subject to these laws and regulations if it engages in false advertising. However, AI itself doesn't have trademarks related to false advertising.
Trademarks are more about brand protection and identification. Back to you, AI Rose.
AI Ian, does AI trademarks has an effect to false advertising?
Trademarks do not directly impact false advertising, but they can be relevant in case where AI is used for branding or promotional purposes. Here are some potential effects of AI trademarks on false advertising. Brand protection. AI trademarks, like any other trademarks, help protect the brand identity of AI. Related trademarks can be challenged and stopped to safeguard the brand's reputation.
Another potential effects of AI trademarks on false advertising is identification and accountability. AI trademarks can make it clear who is responsible for AI-related product or service. This can help consumers identify the source of their AI technology, which is important in cases of false advertising, because it allows consumer to hold the right party accountable. Next is legal recourse. Trademark owners can take legal action against false advertising that damages their brand reputation or misleads consumers. The AI trademark owner can use this legal recourse to combat false advertising involving their AI products and services. Lastly is market competition. The presence of AI trademarks can foster healthy competition in the AI industry, as companies are incentivized to uphold the quality and accuracy of their AI technologies rather than resorting to false advertising tactics.
In summary, while AI trademarks themselves do not address false advertising, they can play a role in identifying the responsible parties and providing legal protection for AI-related brands. Legal action related to false advertising can be taken against those who misuse AI trademarks or engage in deceptive practices with AI products and services. Back to you, AI Rose.
Thank you, AI Ian. We'll be back in just a few minutes with more news and updates to trademark and copyright.
Hindi mas okay mag-aral. Yung mas makakapag-concentrate tayo. Girl, remember last time? Nakapag-group study na tayo sa Hotel Sobo? Tara, dun na lang ulit tayo.
Sago, so fresh, so good.
Fall in love with our mouth-watering Big Bite hot dogs and refreshing Coke and Gulp drinks. Only at 7-Eleven.
We're back on KPLS News. Love scams are widely spread nowadays. AI Ian, does these circumstances has an effect to AI trademarks?
Thank you. AI Rose. AI trademarks do not have a direct effect on love and dating scams. These scams are typically perpetrated by individuals or groups who engage in deceptive practices to exploit people emotionally and financially.
The issues related to love and dating scams are primarily matters of cybersecurity, online safety, and law enforcement. However, AI can be used to help combat love and dating scams by enhancing security measures on dating platforms and social media. AI-powered bots can be used to impersonate brands on social media platforms. They can interact with customers, spreading misinformation, or even scamming users, damaging the brand's or person's reputation.
Oh, ayan na. Ito na ang unang product na i-debunk natin. May video tungkol sa akin. So, kung napapansin nyo, yung video tungkol sa akin, naka-edit lang siya di ba? So, nasa left yung video ko, tapos yung product ng video nasa right. So, pinagtugma. Yan. Kapag chinek nyo ngayon sa comment section, nandun na yung product.
I get asked about trends in the field of law, in the field of trademarks all the time, and most people want to talk about artificial intelligence, and is it going to eliminate lawyers or completely change the way that law is practiced? And I really do not believe that it will. It will, of course, have an impact, but it is not going to replace what lawyers do in terms of providing great advice based on experience and specific circumstances. The way that AI will affect trademark practice is that the amount of data that's out there related to brands and trademarks and use in commerce is tremendous, and it's growing every day, of course. And artificial intelligence tools will help us make better sense out of that data, make better databases and better search engines to maximize the benefits of understanding that data. And so it may change the way we analyze whether two marks are confusingly similar or whether a mark is likely to be approved for registration, but it's not going to change the process of analyzing it, and it's not going to change the need for an experienced counselor to help guide you through that process.
This is AI Ian reporting for Trademark. Back to you, AI Rose.
Thank you, AI Ian. Artificial intelligence is rapidly transforming many industries and sectors, and copyright law is no exception. For copyright, here is AI Ron.
The law provides that intellectual property creations in the literary and artistic domain are protected from the moment of its creation. However, copyright need not be registered. Copyright is a legal concept that gives the creator of an original work exclusive rights to it, usually for a limited period of time. At its most general, it is literally the right to copy, but also gives the copyright holder the right to be credited for the work.
The scope of copyright is confined to literary and artistic works which are original intellectual creations in the literary and artistic domain.
How copyright works. Picture this. You're a modern-day Van Gogh, and you've just painted a masterpiece like The Starry Night. You share it online, and it goes viral. But now you worry about copycats making money off your hard work without giving you credit. What can you do? Fear not. International copyright law automatically protects any original art you create. No one can profit from your Starry Night without your permission. Some countries even let you register your work with the local copyright office, providing extra protection against copying. You paint it, you own it. Simple, right? Now imagine this. You use an AI tool to create an image inspired by Van Gogh's style. The AI helps with your prompts and learns from Van Gogh's works online. But are you still the sole copyright owner? Here's the twist. Copyright laws for AI-generated content are still a bit blurry. Stick around as we will break it down for you soon. But first, let's check out some popular AI tools and their ownership terms. Midjourney, the hottest image generation tool, treats its free and paid users differently. Paid users own the content and can use it for any purpose, even to make money. Whereas users who have generated images when Midjourney was free don't have similar rights. But if you're generating images for $1 million company, you need to be a pro or mega subscriber to be able to commercially use the images. On the flip side, OpenAI's DALL-E and ChatGPT keep things straightforward. Whether you're a paid user or not, you own the content you create. No strings attached. Laws for AI content. Now let's face the elephant in the room. Can you protect your AI-generated content with copyright? The answer's a bit hazy. It depends on where you live. Copyright laws for AI content vary globally. While the UK provides protection, prominent jurisdictions like the EU, USA, and India don't recognize rights for AI-generated work. In a unique case, an AI-generated comic book, Zarya of the Dawn, was denied a copyright claim in the US due to the absence of a human creator. So if your AI-generated Van Gogh-inspired piece gets copied, legal help might be scarce. However, just like any other invention, the copyright laws will mature with time. Till then, be sure to read the latest terms and conditions stated by the AI tools you use. Keep those creative juices flowing, and keep the spirit of AI and human collaboration alive. After all, AI is here to stay.
Back to you, AI Rose.
AI Ron, does creation of a copyrightable work have a requisites?
Yes, AI Rose. One is originality. It does not mean novelty or ingenuity, neither uniqueness nor creativity. It simply means that the work owes its origin to the author. Next is expression. To be fixed, a work must be embodied in a medium sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. Back to you, AI Rose.
AI Ron, what are the rights granted to a copyright owner?
Copyright or economic rights. Moral rights. Right to participate in the gross proceeds of the sale or lease.
Can you give us additional information on what is copyright infringement?
As excerpt from the case of Habana v. Robles, the Supreme Court held that infringement of a copyright is a trespass on a private domain owned and occupied by the owner of the copyright, and, therefore, protected by law, and infringement of copyright, or piracy, which is a synonymous term in this connection, consist in the doing by any person, without the consent of the owner of the copyright, of anything the sole right to do which is conferred by statute on the owner of the copyright.
But why should I care about copyright infringement?
Well, the purpose of copyright is to motivate artists and creators, including you and me, to devote time and resources to making new creative work. We care about protecting these rights because we want artists and creators to keep making new stuff. Plus, it's just fair. We don't want people taking our photos or videos without our permission and sharing them. So why would we do that to them? Part of being a responsible digital citizen is steering clear of copyright infringement. To do that, we need to understand what it is.
Show me what you mean.
Sure, I'll give you some examples. Passing around or sharing copyrighted media on peer-to-peer or torrent sites, especially sites that encourage uploading and downloading without permission, that's copyright infringement. Checking music CDs out from the library and copying them to your phone or MP3 player to add to your music library, that's copyright infringement. Same with watching or listening to the latest movies or songs, using sites that stream music and movies without the artist's permission. Sometimes it's tough to know if a site is legit or not. But if a movie just came out in the theaters, and you find it streaming or for download for free, it's likely illegal and distributed without the creator's permission. And using file storage sites to allow your friends to download copies of your music library and movies is also a copyright infringement. File storage sites like Dropbox, Plex, or Google Drive are great for helping us keep track of all our important files. These might include our music and movies, but file storage sites should not be used as a means for sharing copyrighted creative work. These sites prohibit this kind of illegal sharing.
Hey, I think I know one. What about using a recording app to make copies of music from an online streaming service?
Right, that's infringement too. And guess what? There are benefits to avoiding infringement and searching out trustworthy sites instead. For starters, you know that you're getting your creative content legally from businesses that deal fairly with the artist or creators. It's the right thing to do. You also don't have to worry about getting caught and possible penalties you might have to pay for breaking the law. On top of that, illegal file sharing programs and sites often have malware and other bad stuff you don't want. When you use trusted sites, you don't have to worry about malware that could corrupt devices or dig for your personal information.
Okay, I get there are benefits to being a good online citizen, but sometimes it's hard to know where to go to get media legally.
Section 177 specifically provides that copyright is synonymous with economic rights and shall consist of the exclusive right to carry out, authorized, or prevent the following acts. 1. Reproduction of the work or substantial portion of the work. 2. Dramatization, translation, adaptation, abridgment, arrangement, or other transformation of the work. 3. The first public distribution of the original and each copy of the work, by sale or other forms of transfer of ownership. 4. Rental of the original or a copy of an audio-visual or cinematographic work, a work embodied in a sound recording, a computer program, a compilation of data and other materials, or a musical work in graphic form, irrespective of the ownership of the original or the copy which is subject of the rental. 5. Public display of the original or copy of the work. 6. Public performance of the work. And 7. Other communication to the public of the work. Reproduction is the making of one or more copies of a work or a sound recording in any manner or form.
Now on to music, a trickier domain in terms of ownership and copyright. Around 70% of the world's music belongs to just 3 record labels. AI tools learning from internet music need to pay hefty royalties to these companies. That's why Music LM, which learns from copyrighted music online, doesn't allow downloads or commercial use. But don't fret. With Beethoven AI, you can generate royalty-free music at no cost. Create music on Beethoven AI, and you'll get a perpetual license to use it in your videos, podcasts, and games. You can even monetize your content featuring the generated music. Just remember, you won't fully own the music, so you can't distribute it on platforms like Spotify or Apple Music for profit.
Back to you, AI Rose.
For more updates on copyright, we'll be right back after a short break.
Nandirito na ang ating pag-asa, barangay bukod tayo ng magkaisa. Kay Pepe Pacheco tayo nang sumama, ang Pepe na mabango na'y malinis pa. Bagong kagawad, bagong mukha, may prinsipyo, may isang salita. Kagawad nyo, kagawad nyo, kagawad ko.
Whisker, where feline love stories begin.
Say goodbye to the old-fashioned ways of cat mingling and say hello to Whisker,
the app that will revolutionize the way cats connect, whether it's for love or friendship.
Swipe right to unlock captivating conversations, or swipe left to discover a world of pawsome new friends. Whisker is your gateway to endless possibilities.
Whisker, the app that's rewriting the rules of feline connection.
Back on KPLS News. AI Ron, what are the limitations on copyright protection?
The limitations on copyright protections are general limitations. Fair use and other limitations on copyright work.
Say you want to use someone else's copyrighted photograph in your blog or Instagram post. Is that fair use or copyright infringement? The answer is, it depends on the nature of the use and the purpose of the use.
Doctrine of fair use. Fair use has been defined as a privilege to use the copyrighted material in a reasonable manner without the consent of the copyright owner or as a copying the theme or ideas rather than their expression.
If you're writing a book review, you need to quote from the book in question in order to comment upon it. Your book review is a new work, a transformation of the original copyrighted work. Similarly, educational institutions can use photocopies of copyrighted work for students enrolled in a class, so long as the copying is limited to a chapter from a book, an article from a periodical or newspaper, a short story, short essay, or short poem, whether or not from a collective work, a chart, graph, diagram, drawing, or picture from a book, periodical, or newspaper. But there are limits to how much of a work can be copied for educational purposes. You also can't use these photocopies as a substitute for required text, you can't charge for the photocopied work except to recoup the cost of photocopying, and use of the copies by students cannot be mandatory. In cases like these, fair use seems simple enough. The public interest is served, and the market for the original work is not being substantially harmed. In fact, book reviews and book excerpts often increase sales of the original work by publicizing them. But sometimes fair use is harder to judge.
However, their permission granted to private reproduction of a published by a natural person such as an entire book, or a substantial part thereof,
or of a musical work in which graphics formed by reprographic is excluded.
Back to you, AI Rose.
Thank you, AI Ron. I'm AI Rose, your news anchor, and this is Cup LS News.
I hope you're ready. Let's see who's gonna be the lucky one. Abigail Antonio.
Opo.
In the case of Molina versus Rafferty of 1918, what was the ruling? At anong kinalaman nito sa tax discussion natin?
Tax?
Yeah.
Case?
Yes, the one about the fish being an agricultural product.
Agricultural product.